Right. We are picking from the last from the last week's TUT. We spoke about the corporate customers, the types of corporate customers, and how certain the types of corporate customers as to the sole proprietorships. Then we spoke about the partnerships, the companies, and we spoke about how the limited liabilities are there and the types of companies as to the public, private, as well as overseas offshore companies, and so forth and so on. So we are now little by little moving on to the salient features of the Companies Act. Can I know how many, I see 6 people who have joined in. Can I know the background of yours, the ones who have joined right now? Last time I saw there were participants from corporate banking division. I would like to know how many of you are involved in credit. If I can know, if you can just type on the chat box or unmute your mics and let me know. How many of you have been in credit for the last 2 years or 2 years or more, or currently involved in credit, either in corporate credit or perhaps the retail credit for that matter? Can I just know the background of the participants of today's session? Right, Amma, thank you. You are at corporate credit, corporate banking, Akila, yes. Anyone else? Others are not involved in credit, is it? Right. Hasalaka, thank you. Akila, thank you. Anyone else? Just want to find out how many of you are, or how many of are right now involved in credit, and how many of you have been in credit at least for 2 years? We have 3 other 5 of you all not handling credit or never had handled credit. Right. Anyway, today what we are going to discuss is some salient features of the Companies Act, where these features are important to banks. While there are provisions in the Companies Act, for the companies to get involved in certain concepts, we as bankers' rights sometimes would be perhaps hampered by their rights which the Companies Act had provided for. But nevertheless, still the provisions of the Companies Act also should be going on, as well as the banks also need to perhaps cater those concepts. So in that sense, today we are discussing certain important concepts which as bankers would be of importance to us under the Companies Act. Right. The first is the insolvency test. What do you all know about the insolvency test? Have you all heard about insolvency test? Have you all come across, or what do you all, what do you, what do you feel when it comes to insolvency? What do you feel about when you talk about solvency test? Anything that you would know? What is solvent? Anyone who could tell me what is solvent? If you can just interact with me, it would be easy for me to carry on the session. Anyone who would know what solvent is? Solvency, rather? I'm sure it would have come across, this word would have come across in your, perhaps the subjects you handled in the IBSL. Solvency? Anyone? Anyone who could answer me? Are you all there? Yes. Yes, Hansaka. Hasalaka. Good. The ability to pay one's debts. Solvent is that. So the solvency test, when it comes to companies also, is whether that company has an ability to pay, right? So if you take the slide, solvency test shall be deemed to be satisfied. Can you see that word? Deemed. It need to be, or perhaps it ought to be satisfied. It is something which is ought to be satisfied by the company, that the company is able to pay its debts. Any company would have debts. But the test is the company could pay its debts as and when it becomes due in the normal course of business. Can you see? In the normal course of business, the company needs to have the ability to pay its debts, right? If that is sufficient, one part of your solvency test is done, right? That is one part. In the normal course, you need to pay the company's debt. You must have the ability to pay the company's debts, right? And Apart from that, there is another requirement that the company has to fulfill. That is, the company's assets are greater than the value of the liabilities and the company's stated capital. What are two things? The assets are greater than what? Can you all let me know? Greater than what? The company's assets should be greater than what? If you can let me know. Just want to see whether you all are around. That the company's assets are greater than? That's right. The company's assets are greater than the liabilities, right? And the stated capital. So the main test of a company being the solvency test, there are few things that you need to fulfill. One is it needs to settle its liabilities in the normal course of business as and when it becomes due. As and when it becomes due. And number two, the assets of the company should be greater than the liabilities of the company and the stated capital. So this is basically how the solvency test is done, right? Now, this solvency test is something which is very important to a company, right? Because the solvency test is one of the key tests in a company when it comes to certain important decisions, right? Solvency test becomes a very important test when it comes to certain decisions of the company, right? So before we move into that, how do you determine the solvency test? Who's going to tell you that the company is solvent? Who is going to tell you? Can I know? Who is going to tell you that the company is solvent? Any idea? Who is going to tell you that the company is solvent? Is it the shareholders or is it the board, or who is going to do the solvency test? The auditors of the company will tell you whether the company is solvent or not, right? The auditors of the company. Then they will look at, once this auditors tell you that the company is solvent, then certain decisions in respect of the company can be made. Now, when it comes to the solvency solvency test, the company should take into note, or perhaps the auditors should take into account the most recent financial accounts and the assets and the liabilities of the company. Perhaps the company may have to revalue their assets in order to see whether the company would fulfill the solvency test. Now, can any one of you tell me whether contingent liabilities are part of the liabilities of a company, part of this solvency test? The contingent liabilities. Anyone know what contingent liabilities are? Anyone who would know whether what contingent liability is? Or an example that you could give me as to what a contingent liability is all about? Contingent liability is, for example, is a liability that would occur to you in a time after certain thing happens, after an event happens. For example, if you could see that in a case that you need, after the conclusion of the case, there is a whole lot of sum, a big fine that a company needs to make, right? Those come under contingent liabilities, right? One example for a contingent liability is a court case. Assume that the company has to pay a large sum of money while losing a particular case, right? Those are contingent liabilities, but those contingent liabilities are not part of the solvency test, right? So when it comes to the solvency test, it is important that the company realizes, the moment the company realizes that they cannot pay the liabilities as and when they are due, they need to take certain steps in respect of the company, right? Now, what are the things that the company should take when they know that they cannot pay their liabilities as and when they are due? Or perhaps if the company does not satisfy the solvency test, what are the things that the company should do? Any ideas? Any ideas? If the company is unable to pay the debts, what are the recourses? What are the recourses the company should take? Or what are the things that a company is prohibited from doing? Any ideas? Now, when a company cannot or perhaps is not solvent, or perhaps does not qualify the solvency test, right? The company cannot pay dividends, right? The company cannot pay its dividends to its shareholders, right? One is, let's see. The company, one, cannot pay dividends. Cannot pay dividends to the shareholders, right? Why is that? Why can't you pay the shareholders dividends? Because here you don't have money to pay your liabilities, right? If you don't have money to pay your liabilities, then by paying dividends, you cannot take money out of the company, right? If you don't satisfy the insolvency test, solvency test, rather, then you cannot pay dividends to your shareholders. Why? Here you have a situation where you cannot pay the liabilities. So having had that situation, you cannot let company's money move out to the shareholders, right? Anything else that the company can't do? Anything else that the company can't do? Any idea? The company, in a scenario like this, cannot buy back its own shares. The company cannot buy back its own shares, right? Basically, anything the company is prohibited in taking out the company's money or using company's money for certain activities. The company is prohibited. Now, if you want to buy back your shares, then what do you do? What would the company do if the company wants to buy back the shares? They would pay whom? Can I know? They would pay whom? Whom would they pay if the company wants to buy back shares? Now who are these people? Who has shares? Shareholders, yes, right? So these are the shares. If the company wants to buy back the shares, right, then the company has to pay the shareholder. Then the company has to pay the shareholder, right? If the company has to pay the shareholder, company's money should be pumped to the shareholder, right? Because of that, the companies are prohibited from buying its shares when the company does not fulfill the the solvency test, right? But there are certain instances, though the company does not qualify the solvency test, still the company is bound to the shareholders to pay money. Any idea as to what they are? In very limited circumstances. Generally, a company, if it doesn't satisfy the solvency test, the company cannot buy back its shares. But that means they cannot pay the shareholders, right? But in certain limited instances, the company needs to pay the shareholders. Can anyone guess what these situation, what type of situation would arise? I mean, in what type of situation would the company be compelled to pay the shareholders? Any idea? You know that when a shareholder invests in a company, right? He is issued what? What is he issued? Shares, right? He is issued shares, right? There are different types of shares, right? There are different types of shares, which we will come to later, right? Out of which one type of share is that the company tells the shareholder, right, you bring in money after a certain date, the company promises to buy back the shares, right? The company promises to buy back the shares. That means company promises to redeem the shares. Have you seen shares of this nature with the option of, or perhaps redeemable shares? Have you seen? Right? Redeemable shares. Yes, Asalaka, there are types of shares. Preference shares are also something of that nature, right? But in this, the company requests is bound to the shareholder, because the company has promised the shareholder that it would redeem. So in that instance, though the solvency test is not passed, because the company has given a promise to the shareholder, the company needs to pay, right? The company needs to pay. Any questions on that before I move a little bit further on solvency? Right. Now, the nature of this solvency test is this. Now, when the solvency test is not passed, right? And the directors of the company, this is not passed, but the directors of the company takes decisions, right? They take decisions putting aside this solvency test, right? For example, when it comes to a distribution, it is mandatory that the solvency test is to be satisfied, right? Now, if these directors, knowing that the solvency test is not satisfied, goes ahead with this distribution, right? Then they can be personally liable, right? Can you see? They can be personally liable. This is now when it comes to a company, you all know the liability of a company is to what? It is confined to what? A liability of a company is confined to what? Can I get an answer? The liability of a company is confined to the assets of the company. Generally, the liability of a company is confined to the assets of the company. But in the New Companies Act, this is one of the instances where the directors, the company is liable, or perhaps the company is liable, draws down to the director's liability, director's personal liability. Did you get my point? Generally, a company is liable to the status of its assets, right? Directors are not personally liable, but there are certain instances where directors are personally liable. And this is one of those instances, right? Say, for example, all of these directors agreed to the distribution when the solvency test was not satisfied. Then they are all personally liable, right? But then here there are 5 directors, right? 2 of them dissented. That means disagreed. They disagreed on this distribution, but three of them agreed, right? 2 of them disagreed on the distribution when the solvency test was not satisfied, right? But 3 agreed. Do you think the whole company, now there is a majority here, right? Majority of the directors have agreed, right? What are your thoughts? Do you think that all these directors are liable, personally liable, or some of them are personally liable? Can I get an answer? Any idea? Who do you think is liable in this instance? Here we have a board of directors of 5, right? The solvency test is not satisfied, right? They want to do a distribution to the shareholders. What is the distribution to the shareholders? That is, they need to say declare a dividend. That is also a distribution, right? Declare a dividend. They need to declare a dividend. Out of the 5, 2 directors are in disagreement. 3 directors are in agreement for the distribution, and they go ahead with the distribution. But then it is wrong. What I want to know is whether all these directors are liable or some of them are liable. Any answers? Under the Companies Act, since there are no answers, under the Companies Act, the people who agreed are personally liable. Right? So, if you happen to be a director of a company after perhaps your retirement, or if you feel like leaving the bank and opening up a company or joining a company in the directorship, right? Always make sure that if something is not provided by the Companies Act, you make sure that you mark your dissentment. That you always say that you disagree, right? There is a fine, right? There is a fine on this, and it is a personal liability on the part of the director, right? So that is why this test becomes very, very important when it comes to certain company decisions, right? Any questions over this? Any questions? Any questions over this? Right. Since we have no questions, we are moving on. Okay. Right. Financial assistance to buy its own shares, right? What is the financial assistance that we are talking of? We are talking of when companies come to us for loans to buy their shares, right? I will explain to you from an example, right? Now, here is a company. Company A, and here is company B, right? Company B wants to purchase the entirety of the shares of A company, right? Say it's valued at 100 million. Once again, this A company is there. They want to sell the company. Here is a prospective purchaser, B company. right, who wants to buy the shares of a company which is valued at 100 million, right? Though it is so, B company right now doesn't want to use its cash, right? What they have? They come and seek a loan, right? They come and seek a loan from you. He says, right now, I have no, as now, when you take a loan, you need to take a security loan. Right. But B comes and says, well, at this moment, I don't have securities, or perhaps all my securities have been mortgaged to banks. And right now, I do not have any security to give you, right? When the company comes and tells this 100 million loan, if it is a big company, of course, that's nothing much for you. But if it is a small company, would you like to give it clean? Yes or no? If it is a small company, 100 million, would you like to give it clean or not? No, yes. Then you keep on asking for a security, right? But then they don't have any security to give. Then a bright idea comes to them. They see that this A company owns a property, right? This A company owns a property. B says that A company owns a property, but what his argument is, anyway, when I buy this is going to be my company, this is going to be me, I'm the shareholder, and therefore, please take this property as a mortgage, right? And give me the 100 million loan. Right? They would come up and tell something like this. Here there is a property, a company owns it, right? Therefore, you take a mortgage over this, right? And you give me 100 million so that I could purchase the shares of this company. Understood? Right. Now, under the Companies Act, a company cannot give direct or indirect financial assistance to purchase shares, right? A company cannot give direct or indirect financial assistance to purchase shares, right? That's what is there in the Companies Act, except in certain instances, right? As a rule, a company cannot give financial assistance, right? Now, in this case, what is the direct or perhaps the indirect assistance that the company is giving to buy the shares? Whose shares is the company buying? A's shares, yes, A's shares, right? To buy my own shares, what is the assistance that A is giving? Can anyone tell me? What is the assistance that A is giving B? What is the assistance rather, A is giving?
Miss, can you repeat that question again?
Yes. Is it from the beginning
No, no. Now, what you said?
yes. What I want to find out is, in the Companies Act, it is said that a company cannot give direct or indirect financial assistance to purchase its own shares, right? Unless in certain instances, right? Now here there is a situation, B company is going to purchase A's shares, right? Now to purchase, A going to purchase its own shares is giving an assistance indirectly or directly to purchase, is giving some help to purchase its own shares to B. What is the help that A is going to give? Did you get my point?
Yes,
What
ma'am.
is it? Sorry? What is the assistance that A is going to give B to buy shares? What is the assistance? Exactly. He is going to provide a security. A is going to provide its own security to buy his own shares, right? So there is a norm or perhaps a restriction. You cannot leverage on your own assets to purchase shares, right? You cannot leverage on your assets to purchase shares. But having said that, I'm sure the ones who are in the corporate banking division would have perhaps come across these type of loans. Have you all come across? Anyone who has come across? No? Or yes? No. Right. Now, as in general terms, you cannot leverage on your own assets to when it comes to giving financial, you cannot leverage on your own assets when it comes to purchasing of shares, right? So in this instance, B, right? We cannot, from the banker's point of view, right? From the banker's point of view, we cannot give a loan to B by mortgaging A's property for the purpose of purchasing A's shares, right? So that means B cannot mortgage A's property to buy A's shares, right? B cannot mortgage A's property to buy A's shares. Is this clear to you? Because if you are you cannot give financial assistance to buy your own shares. You cannot give your company assets to anyone who's going to buy your own shares. Understood? Right? So B basically cannot mortgage A's property to buy A's shares. But B can bring his own security to buy A's shares, right? Now, this as a whole would apply to limited companies, PLCs, right? Private companies, so forth and so on, right? But there is an exception to private companies, right? There is an exception to private companies. That is, can I erase this? Can I erase this? Okay, right. Right? Though the Companies Act says so, when it comes to private companies, right? As you all know, the private companies are the small companies. They have minimum two share. Well, they can have. They are not as big as they are not perhaps regulated as the limited companies. They are the most simplest and the most commonest companies, right? So under the private companies, if a company, private company, right? You have to make sure this word private company. If a private company unanimously pass a shareholders resolution, right? If you pass a shareholders resolution, then the B company can mortgage A's property and get assistance for shares, right? Now in the Companies Act, there is something called a schedule, right? Certain barriers in the Companies Act which are imposed for companies can be lifted for private companies if the shareholders passes a unanimous resolution, right? I'll repeat it. In the Companies Act, there is a schedule, right? Which says certain barriers, like this is one, that you cannot give financial assistance to in respect of companies. Certain barriers which are there in respect of companies, right? In respect of all the companies, right? Can be lifted only in respect of private companies if the shareholders unanimously pass a resolution, right? So, in this schedule, giving financial assistance to a company, right, can be lifted by a shareholders resolution, right? And with that, you can mortgage A's property and give financial assistance to purchase shares, right? Anything that is not clear in this? This is the only way that you can do. Under the Companies Act, you cannot give financial assistance to companies to buy back its own shares unless in certain instances, right? But when it comes to private companies only, you can pass a unanimous shareholder resolution. Now, what's a unanimous shareholder resolution? Now, when it comes to the board, when board of directors sit and pass as a resolution, it becomes what? Director's resolution. Or generally, we don't use the word director's resolution, you say a board resolution. You use the word board resolution when the directors of the company pass as a resolution, right? Similarly, shareholders of the company also can hold meetings. Can hold meetings not as and when they want, but under the provisions of the Companies Act, right? Under the provisions of the Companies Act, shareholders also can have meetings, right? In a meeting of that nature, all the shareholders must agree to this, right? All the shareholders must agree. Otherwise, you can't leverage on the assets, right? That is why it is very specifically said, unanimous resolution passed by the shareholders, right? Unanimous resolution passed by the shareholders. This again, the property is A's property, right? The property is A's. There is a question whether the property, whose property is this? Here it's A's property. This is B company. B doesn't have any assets, right? Or has assets, but rather at this moment they can't give anything to the bank. It is A company's assets. So A company's shareholders, right? Shareholders passes a unanimous resolution and allow A's property to be mortgaged to your bank and to give money to the B company to buy shares, right? Understood? Right. Now, have you all heard of this word, ratification? Ratification. Anyone knows anything about what do you mean by ratify? Any idea? What do you mean by ratify? Ratification is you do something first, right? Without approval. Later on, you say what he did is correct. Ratify. Right? That is something which you do without approval, right? But later on, your act is being authorized by someone, then you say it is ratified, right? But here, when it comes to the shareholders' resolution, it cannot be ratified, right? It cannot be ratified. It needs to be passed before we take the mortgage, right? Basically, what we need to see is, without authority of the shareholders, you cannot take a mortgage over this, right? First, you need to take the approval of the board, shareholders, and then only you can do the mortgage. Is it clear to you? Or not clear, or do you want me to explain this again? Do you want me to explain this again, or can we move on from here? I have not got either a yes or no. Is the approval? Yes, exactly. It is only in respect of the asset of the company, that is the security. The security, if you're using anything of this company, right? The security of this company, it can be a property, it can be, basically you will not get stocks, because it's any security that you take, right? Understood? Hasalaka, did that answer your question? Right. Now, since we came to ratification, this is something, this is one option actually that you need to know, right? This is not in respect of financial assistance, but this is something which you ought to know, right? Now, the board, right? Generally, a board makes decisions and you make them as resolutions, right? Now, maybe your perhaps when you give a loan, you need a board resolution. Why do you need a board resolution when you give a loan? Why do you need a board resolution when you give a loan to a company? What is the reason that you need to give a, why do you get a board resolution from a company when you give a loan? Can I know? Yes. To obtain the consent of the company. The company is not a natural person. The directors drive the company. The decision of the company is being put forward by the directors at a directors meeting, which is called the board sitting and deciding and taking a decision in respect of the company. Right. Now, how do you all request? Now today you are granting the loan, right? Today you are granting the loan, right? On which date do you want the board resolution? Today is the 26th, right? Today is the 26th. Today you are granting the loan. On which date do you want the board resolution to be? What is the
When
date?
the meeting held at the board of directors.
When the meeting held at the board of directors, yes. Is it a date before this, or is it a date after this, or is it on this date? Yes, Asalaka, I see an answer. Today or before. Yes. Why? Because the company must come into the decision of taking a loan, right? First, the company must come into a decision of taking the loan, and then you need to decide, you need to tell the bank, and at this point, right? But supposing, yes, the board resolution should be on this date or before this, right? Now, supposing you have not obtained the board resolution, right? You have perhaps have not asked the customer to bring the board resolution. Oversight. Now, what do you do? Now, what do you do? There is an oversight. You have not asked for the board resolution. Now, what do you do?
Get a certified BR.
Sorry? Get a?
Obtain a certified BR.
Get a certified board resolution. Is it? Get a
Yes.
certified BR. Right. You can get a certified BR, but what I want to know is, now you have not, now the day has passed. You have already granted. How do you get, perhaps the company has also not resolved. Company has also not resolved. There is no board resolution. The board has not met. Then what do you do? Then what do you do? Yes, I have two answers here. Then you can get a ratification, right? Ratification is, now here at this point, you have granted the loan, but you are getting a board resolution on the 30th, right? At this time, you cannot say that you resolved. You cannot say that, because this act has already happened, right? Therefore, in your board resolution, you say the company, this is how you do say, have the wording. Hereby ratify, right? The company hereby ratify whatever, maybe having taken a loan from X bank, and goes on like that, right? The company hereby ratify whatever the act done by the directors, right? If it is something before, how does the wordings go? The company hereby what? What is the word here? If it is something before, in the normal course, what do you do? What is the word that comes here? The company hereby what? The company hereby, that's right, resolves, right? The company hereby resolves, right? So Generally, if the company has not resolved, you have an option that you can ratify this, right? But if there is one instance in the Companies Act where a decision of the shareholders cannot be ratified, it has to be resolved. That is, before doing a certain act, you need to get the permission of the shareholder, right? Is that clear? Right. We are moving on to stated capital. Right. What is a stated capital? Any answers? Any answers? What is a stated capital? Anything that you know about it? Stated capital? Right. The stated capital is the total amount received by the company and due and payable to the company in respect of issue of shares and in respect of calls on shares, right? What do you gather from that stated capital? Right? Stated capital now, when a company, when a shareholder invests money, you issue shares, right? So this is the amount received by the company, right? When a shareholder comes, puts in money, he buys shares of the company. So the total amount received by this company, right, for the shares that the company has issued. But there are types of shares where the shareholder brings in only a certain percentage of money, right? A certain percentage. The balance percentage will actually come to the company on a later date, right? There are certain types of shares where a certain percentage will be paid to the company and the balance would come to the company at a later date, right? That is, in actual fact, as of today, this amount has not reached the company, right? This amount has not reached the company. But when you are to calculate the stated capital of the company, you need to calculate the actual monies and the monies that are to be received, right? With both of them will amount to the stated capital of the company, right? So under the previous act, there were all par values and share premium accounts and all these things. They are now repealed, right? Right. Now, reduction of stated capital. Is reduction of stated capital a good thing or a bad thing? Is reduction of stated capital a good thing or a bad thing? To reduce the share capital, stated capital? Now, under the Companies Act, right? There is provision, right? There is provision under the Companies Act to reduce the stated capital. Right? Now, under the earlier regime, it was very difficult to do this, to reduce the stated capital. Right? It was very difficult to do this. You had to go to court to do this. Right? But in the new Companies Act, this has been made very easy because you need to only pass a special resolution. Only a special resolution. What is a special resolution? Special resolution is there are people, say in a normal company, you need to have more than 75% of the people who are entitled to vote. You need a majority of 75 and more to pass a special resolution, right? So if a company passes a special resolution, then the company can reduce its stated capital, right? The company can reduce its stated capital. Now, what we can do is, have you seen in your offer letters, have you all read your offer letters, by the way? Anyone who had read the offer letters? I know your secretary types, or perhaps your credit admin department types. Yes, very good. I'm happy to see that some have read. That's very good. What does it state about the stated capital? Anything that is stated about the stated capital in your offer letters? Anything that is mentioned in your offer letters about the stated capital? It says the company cannot reduce its stated capital without the prior consent of the bank, right? It always says that the company's stated capital cannot be reduced without the prior consent of the bank, right? Okay. We are moving on to issue of shares, right? As I told you, when a company wants to raise funds, there are many ways that a company could do so, right? One way is issuing shares. Issuing shares in a private company, it's different. In a PLC, it is different, right? But it is the same concept. What is different is perhaps the procedures or perhaps the regulations that one needs to follow, right? When it comes to PLCs, if you're going to issue shares, you have to have a prospectus. You need to issue, the company needs to issue a prospectus. Has anyone seen a prospectus? Anyone who has seen a prospectus? The recent past, of course, I don't know whether we saw any prospectus. I think there was one or two initial IPOs coming up or which had come up. In this financial world, if there is anything of that nature, like IPOs coming in or perhaps issuing of debentures, I suggest that you get personally involved in those, whether you have maybe not to invest a large bucket on those, but at least to get the experience from a customer's point of view or to get familiarized with the documentation. If you are not familiar, you need to, as bankers, it's good. It's good to be part of those debenture issues or perhaps IPOs. When you read something, you will understand them better. If you read a note on a initial public offering or a debenture issue or something like that, if you do it practically, you will understand, yeah, this is why I did it, right? So if you happen to come across any of those, try and see whether you could get involved in those, get involved on those so that, you can perhaps have a bit of a practical type of experience, right? So we were at issue of shares, we were off the prospectus. Now, the importance of the prospectus is the directors are liable for the information given in the prospectus, right? You can't lie to the general public when it comes to prospectus. And as you can see in the slide, there are two types of liabilities. Can you see? There are two types of liabilities. A civil liability as well as a criminal liability, right? We're talking about prospectus, right? In the prospectus, directors have a huge responsibility, right, to include what is correct, right, to give accurate information, or else there is provisions in the Companies Act to make them liable. Right, to make them liable, right? The civil liability is anyone on the prospectus makes an investment and suffers any loss or damage due to the reason of an untrue statement contained in the prospectus, right? There will be civil liability as well as criminal liability, and there will be a fine of 500,000 and imprisonment of up to 2 years or both, right? Can you see the gravity of it, right? In a prospectus, it is very, very important that you give true statements. If they are untrue, there will be criminal as well as civil liability. The criminal liability is very huge. You can be imprisoned up to 2 years and a fine of 500,000 or both, right? Right. We are moving on to type of shares, right? What are the type of shares that you have come across? Yes, can I get a bit of interaction with you all? What are the types of shares that you have heard of, or perhaps purchased from the stock market? Can I know any types of shares? Any types of
equity shares?
Sorry?
Equity shares.
Equity shares. Okay. Ordinary shares, preference shares. Yes. We have ordinary shares. What do you mean by ordinary shares? It is they are the most basic type of shares, right? Then it has unlimited rights. As a shareholder, anything which is given in the Companies Act as rights of a shareholder, anything which is given in the Companies Act as, you know, these are your rights as a shareholder, 1, 2, 3, 4, 5, right? If they are there, all those will come under the ordinary shares. That is, a person who buys ordinary shares will be privileged to have all the rights which are there for a shareholder. Right? They will have the privilege of having this. Right? Preference shares. Preference shares is anyone who buys these shares will be above them, will be above the ordinary shares because they would be the most preferred class of shares. Any benefit first they will get before it goes to the other type of shareholders, right? Then you have deferred shares. Now, what are deferred shares? Shares, they have only limited set of shares, right? Maybe for income or profit, they have limited type of shares, limited type of rights when it comes to deferred shares, right? Then you also have non-voting shares, right? From the very word of it, you don't have the power to vote, but basically you will have all the other powers, right? Then you also have what is called redeemable shares, right? They are created on the understanding that the company will buy it back one day, right? Here, these type of shares, you have purchased it from the company, right? But when it says redeemable, who's going to redeem this? The company is going to make good to the shareholder. The company is going to pay the shareholder, right? Or perhaps they are going to buy back the redeemable shares, right? So those are the type of shares that we generally see in the market, right? So pricing of shares, shares must be issued for consideration. That means for value, which the board of directors resolve to be fair and reasonable to the company and to all existing shareholders, right? This is very important. The decision of pricing of shares lies with the what? Right. It lies with the board. The pricing, the decision lies with the board, right? So before we move on, would you like to have a break at this moment, or shall we go on till 3:30 and then have a break? If I can know. Continue. Right. Okay. Right. So we spoke about pricing of shares. Right. Procedure to increase the stated capital. Now, we talked about the stated capital, right? Just a rapid revision. Tell me what the stated capital is. Yes? Anyone who could tell me what the stated capital is? Yes? What is the stated capital? The total amounts, what? The total amount received by the company or which is due to the company in respect of what? In respect of what? What is due to the company in respect of what? Total amounts received by the company or which are due and payable to the company in respect of what? If I can know, in respect of what? Stated capital? In respect of shares, right? This is in respect of shares, right? Now, how do you increase the stated capital? How do you increase the stated capital? The decision to be taken in accordance with the articles of the company, right? You have to see how the capital is to be increased according to your articles, right? The company needs to see, go through the articles and see. First, before anyone else, the shareholders should take a decision, right? Shareholders should call what is called an extraordinary general meeting, right? They should call for an extraordinary general meeting and take a decision at the shareholders meeting, right? Then the board of directors, once this is done by the shareholders, then the board of directors needs to resolve, right? The board of directors needs to resolve, right? That means, what do you mean by increasing the stated capital? You are increasing more and more. What are you? What do you mean by increasing the share capital? You are issuing more and more. What? What are you issuing? That's right. You issue more shares, right? When you issue shares, there is a procedure, right? There is a procedure to be followed. Where do you think? You need to inform the registrar of companies, right? Then you need to have your pricing and pay the relevant dues to authorities, right? Right. We are moving on to distributions to shareholder, right? We talked a little bit on the distributions. What is a distribution? Distribution is either you directly give the shareholder some benefit, right? Or you indirectly give the shareholder some benefit, right? And that is called distribution, right? So this is a way where money goes out of the company, right? This is a way where money goes out of the company, right? So what are the things? Okay, we will talk about the impact on the distribution. Right. When it comes to distribution, as I told you in the previous, at the beginning of this session, when it comes to a distribution, the company needs to satisfy what? Satisfy what? The solvency test. They have to satisfy the solvency test, right? Have you seen in your perhaps security documents that distributions up to a certain percentage perhaps would need banks concurrence? Have you seen something of that nature? Have you seen in your security documentations? In some of your security documents, you would see clauses saying that the company, perhaps if the company is going to give a certain percentage of the distribution, that prior approval of the bank has to be taken, right? In most of the cases in these security documents, perhaps the companies generally don't read. But if you actually see those clauses, a very perhaps a vigilant person from the company's end would only see them. Because in actual fact, what happens is companies are always, perhaps some companies are in the, or perhaps you would say these are all standard formats and it's very difficult to change them. But certain top corporates, I believe, it is not the case. Some top corporates, they would request changing at least 50% of your offer letter, or perhaps the other security documents that the company signs. I'm sure, have you all come across those type of situations? Anyone who has come across situations where your corporate customers have requested to change certain clauses in the offer letter, or perhaps change certain clauses in the security documents that you get them to sign? Anyone? None of you all have come across? Yes. So what are the type of documents they would request you to change? What is the type of document? What are the general clauses that they would request you to change? Or what is the most commonest document, commonest, perhaps, yes, the offer letter. Offer letter is the most commonest document that, the companies would request you to change. If you happen to read your offer letter, which I was happy to see if you had done that, I think because the customers had requested you to change them, it made you read it, I believe. Or perhaps on your own motion, you would have done it in good faith. Whatever the reason may it be, if you come across, apart from the normal conditions that in respect of securities or in respect of the bank's rules and regulations, there are quite a few of conditions or perhaps things that you have mentioned in your offer letter. What have you mentioned in respect of your stated capital? The company's stated capital? Anything that in your offer letters that you all have mentioned that about about that company's stated capital? We have seen in offer letters that we say that the company should not reduce their stated capital, right? You should not reduce their stated capital. In some instances, I have seen when you give loans, you have made conditions to the customer saying that prior to the disbursement of the loan, that the stated capital needs to be what? Needs to be increased, right? I have seen in some facility papers that this condition is being brought to the offer letter, or perhaps a condition to the customer that the stated capital has to be increased, right? So we were talking about distribution, and then as I told you, certain percentage, sometimes we will request the customers to inform us when the thresholds are after above a certain percentage distributions, right? As a just can I know, as a practice, have any one of you all obtained solvency certificates from your customers? Does it actually in practical sense happen? Have you all seen solvency certificates, solvency test certificates? Or is it not, perhaps we all talk about solvency tests, but in actual fact, in the practical scenario, I think, have any one of you all seen a solvency certificate? No, yes. We don't take them, but the solvency certificate plays a major role in deciding companies, because you take a distribution, you take anything that deals with the financials of the company, solvency test becomes an important part, right? So we will have a small break now, and perhaps meet after about 20 minutes time before we move on to repurchase of shares. We're talking about repurchase of shares. This is also one of the provisions which are there in the Companies Act, which we slightly touched on. Right? When it comes to repurchase of shares, the main thing is a company can repurchase of their shares only if the articles provide for it, right? And with the approval of the board, right? Now, this is an important thing. You know, articles of the company is the constitution of the company, right? Articles provide for maybe shares of the company, then the, how the meetings are being held, and so forth and so on, like we discussed on the last occasion, right? So when it comes to repurchase of shares, it is a requirement that the articles of the company should have a provision in respect of repurchase of shares, right? It has to have a provision in the articles of the company that the repurchase of shares are provided for, right? Now tell me, if the articles do not provide for such repurchase of shares, then what do you do? Then what do you do? If there are no provisions in the articles to repurchase shares, and the company itself wants to repurchase shares, then what can you do? What is the option available to the company in a situation of that nature? Any guesses? Any guesses? What the company needs to do? The company has an option of amending the articles, right? They have the option of amending the articles in order to include the repurchase of the shares of the company, right? Now, other than for the provisions in the articles, the board must approve the repurchase, right? The board just can't approve the repurchase, right? It needs to see certain things. Now, repurchase is, as you know, you issue shares to the issue shares of the company and you purchase them back. Then the number of shares will be less, right? The number of shares would be less. Now, when it comes to a repurchase of shares, the company needs to look into whether it is in the interest of the company, whether it is beneficial for the company, right? Number two is the terms of the offer, at which price that you need to repurchase, right? The price that you are required, that you have decided to repurchase, the company directors needs to get an opinion from the who they need to get an opinion from the auditors as to the amount of the repurchase, right? And the other thing is the company should not be aware of material information which is affecting the value of the shares which has not been disclosed to the shareholders, right? Three things. Once again, the board must resolve that the acquisition of the repurchase of shares are in the best interest of the company. That's number one, right? Number two, the company board must resolve that the terms of the offer and the consideration to be paid is in the opinion of the company auditor is fair, right? The auditors will give their recommendations and the board needs to decide whether those consideration is fair and that the company directors are not aware of any material information affecting the value of the shares which has not been disclosed to the shareholders, right? Also, if any voting right of a shareholder is affected by this repurchase, if anything is affected, the board must also resolve that the offer is shared to the shareholders to whom the offer is not made. The board can resolve as to whom that they are going to resolve to make this repurchase of share option open to, right? Now, as a bank, what we can do is we can perhaps get an undertaking from the company that they would not repurchase its own shares without the bank's prior written approval, right? Those are the options that we as a bank could take, right? Right, we spoke about restrictions on giving financial assistance on the earlier on an earlier occasion. Right. We are moving on to amalgamations. Right? We have a company. Then we have the company. What do you mean by amalgamating? What does this word constitute? Amalgamating? To bring together, right? Now, under the normal companies provisions, amalgamation can be in two forms, right? One is a company can amalgamate with B company, right? When A company, amalgamates with B company, the B company is still there and A company is no more. A is no more. Once again, if A is to be amalgamated with B, if A is to be amalgamated with B, there can be an option where B will be in existence, right? And A will go out of the picture, right? So in general terms, what happens is A is no more, right? What happens to, if A is no more, what happens to A's shares? What happens to A's shares? Can I know? What will happen to A's shares if A is amalgamated with B? Yes, A's shares will be acquired by B, right? Now, once A's shares are acquired by B, at the register of companies, right, there will be no A company. The file in respect of A will be closed, right? The file in respect of A will be closed. So in actual fact, A is not in existence. A is not in existence. Nor his shares, nor the company number, those are not there, right? PV numbers, PVC numbers, nothing is there, right? When it comes to assets of the company, what happens? For example, we'll take something like this. Here we have an instance where A is amalgamating with B. A is not in existence. Now, A has a property. There is a transfer deed. Now, whose name is in this property? This property? Transfer deed? In whose name originally? Originally, under whose name is this transfer deed? Yes, it's in the name of A, right? Now, when this is acquired by B, Now this company is no more. There is no A company. So now what happens to the validity of this transfer deed? What do you think? What is the validity of this transfer deed? Because there is no A in the land registry records. There is no physical company. Then what is the position of the transfer deed? What do you think? What is the position of the transfer deed? Do you think the transfer deed is valid still, or it is not? When A company amalgamates with B company, A company is no more, and A's assets or A's property, the name of the company is no more. So then what is the position of the asset, or perhaps the transfer deed of A company's transfer? What is the perhaps the validity of the transfer deed which A has? Yes, I have an answer here saying that the transfer deed is valid, but still it is in A's name. Then what is the situation? It is still in A's name, whereas A is no more. Once this company amalgamates with B, there is something called the what? Amalgamation certificate, which is issued by the Register of Companies, right? What do you call this certificate? Amalgamation certificate, right? So along with this certificate, you can keep the deed intact, because there is a provision in the Companies Act that whatever the assets of A is now deemed to be assets of B company. I repeat it. There is a provision in the Companies Act that whatever the assets of A is now deemed to be assets of B. Now, the fact that the transfer deed is in A's name doesn't matter as far as you have the amalgamation certificate attached to the deed. Understood? A's assets are deemed to be B's assets. The fact that the transfer deed carries A's name is not a matter, because once this amalgamation certificate is issued, it gives value to the transfer deed. Have you seen an amalgamation certificate? Have you all come across in your day-to-day operations an amalgamation certificate? No? Right. In an amalgamation certificate, as it generally it would say A has amalgamated with B and would now continue in B's name, right? A has amalgamated with B and is now continuing under B's name, right? Now, this is in respect of assets, right? Now, in respect of liabilities, it is the same, right? The Companies Act has a provision to say any assets and liabilities of A is deemed to be assets and liabilities of B company, right? Now, have you in your day-to-day perhaps experience come across companies giving notice about amalgamations? Have you come across companies giving notice about amalgamations? Have you all come across? No? Generally, the companies need to give notice to its creditors, right? Under the provisions of the Companies Act, before an amalgamation is to take place, right? It is before. Remember that. Before an amalgamation is to take place, you need to get notice. Companies generally give you notice. It will say under which section, right? It is going to resolve, right? And it will go on like this, right? Then the other form of amalgamation is say there is A company, right? Here there is B company. They amalgamate and form what is called the new company, right? The company C. The most commonest form of amalgamation is this. This is very rare, right? Same again, when there is an amalgamation, right, there needs to be something called this. Right? You need to have what is called an amalgamation proposal from the company. Company perhaps will not give you this, right? The amalgamation proposal will be approved by the board of both these companies, right? Once they are approved, the amalgamation will take place according to this, right? According to the proposal. Any questions on that amalgamation? Any questions? Right. We are moving on. Sometimes, perhaps, the amalgamation might affect on the credit quality of the company, right? If it goes on like this, say this was, you had a very good credit evaluation, right? And you don't know anything about this company, right? You don't know anything about this particular company. So it can affect the credit quality of your assessment, right? So what you can do is, and what you all generally do is, in your offer letter, you say that any amalgamation should not be done without the prior written consent of the bank, right? Without the prior written consent of the bank, you cannot amalgamate with any company. That's how you handle that situation, right? Now, in this instance, though it is uh, not in respect of amalgamation, I am going to take this shareholders, right? This is also a concept which is coming under the Companies Act. Since it is quite related, I thought I would take this. Here there is a company. Change in shareholders. I'm sure this is very common, the change in shareholders. Have you all come across change in shareholders? Right? Here there is a company, A company. B and C are shareholders of the company. Right? Here there are two, perhaps, individuals or perhaps a company, right? You get a letter from a company saying that D and E are the shareholders of the A company, right? Now, generally, according to your offer letter, there is a restriction on shareholders. What is the restriction? If you all happen to read the offer letter, what is the restriction that you have on the shareholders in your offer letters? Has any one of you come across? In respect of the shareholders, right? In respect of the shareholders, there is a restriction. What is the restriction? That's what I'm going to ask you. Anyone who could answer me? Yes, shareholding should not be changed exactly without the consent. Thank you, Akila. The shareholding structure shall not be changed without the prior written what? Consent. Prior written consent of the bank. But generally, when do this prior written consent is sought for, or is it only notification? There are it's two different concepts, right? When you say prior written consent of the bank, right, that means before you do this change, right, before you do this change, you must get the consent of the bank. You must get the consent of the bank, right? But in 100% cases, we don't get prior written, customers do not write to us for prior written consent. But what happens is they do the change and quickly inform us, that is, they notify us. Two different concepts, right? There are two different concepts. Notification is one, prior written consent is one, right? Now, say, for example, in most of the cases, you get the notification, no? Now you get the notification. That's saying that they have changed their shareholding. Now this letter has come to you. Now what do you do with that letter? You go running to your legal department. Is it the case? Yes or no? Or what do you all do? If a letter of that nature comes to you, what do you do? Have you all received certain letters like that? Have you all come across letters of that nature? We were discussing, Yumal, about the change in shareholding, right? If a company has changed its shareholders, right, and have informed the bank by a letter, generally it is not informing the bank. You have to get the prior written consent of the bank. That is how you word it in your offer letter. But nevertheless, if the company has not obtained our approval, but notified us, a letter has now come to you that the shareholders have changed. Now what do you do? That was my question. Now what do you do? Seems that a similar letter has not reached you. Is it the case? Right. If the shareholders have changed, right, there is nothing that you need to do in respect of matters. Legally, there is no implication. Legally, there is no implication because the company can change its shareholders, right? There is no legal implication. But the implication is on your what? The implication is on your what? Any answers? The implication is on your credit decision, right? The implication is in your credit decision, right? Why do I say this? I say this because of this. This is a company, right? This is a subsidiary of, say, JKH Holdings. Right? This is a new company, right? But still, since JKH Holding is the major shareholder, of this company, right? You are sure that this loan will not be defaulted. That is your credit decision. On that basis, you go and lend to A, right? Here, JKH is the major shareholder of this A company. A company is relatively new, right? But you still go and lend to A, right? Because JKH is the major shareholder. That is your credit decision, right? But the moment JKH Holding steps out, right, and the shareholding changes to some X company, your credit decision is affected, right? Your credit decision is affected. Now, in this scenario, what you need to see is what is the security? What is the security that you have taken in respect of A's loan? Right? All what you have to see is what is the security that you have taken in respect of A's loan. Right? If you have taken a loan of, if you have taken a corporate guarantee, of JKH, then you might have a problem, right? You might have a problem and you need to see whether you need to get the corporate guarantee from the new company as well, right? That is your decision on the change of the shareholders is basically a credit decision that you must see whether your credit evaluation was on the basis of the shareholder, right? And whether that credit evaluation had been affected with the change of shareholding, right? Because for some companies, because of the fact they are the major shareholder, that we do give loans. That is the only credit, that is the only thing that we would consider, right? So in that context, you need to see whether your credit evaluation has been affected. Is it clear? Is it clear to you? Are you all there? Yes, right. Thank you. Right. Now, we will take a change of directors also here. We spoke about directors, right? Now, in a company, directors come in, they might go out, right? When there is a change, you file what? What is the form that the company files? Form what? What is the company?
Form 20.
Yes.
Form 20.
Yes. Form 20. Now you receive a Form 20 from the company, right? When you receive a Form 20 of the company, it will say, these are the directors who have ceased. Ceased means what? Who have left. Right? And it will also say who are the directors who are in. Right? Now, this change generally has not much of a legal effect in respect of your security, right? But you have to look at this once again in two different aspects, right? In respect of your credit decision and in respect of your mandate. Understood? Your credit decision would have been based on the strength of a director. Maybe he is a well-known director who is perhaps he is the managing director, and you know where if he is there, the company would be driven safely, right? He is a person who would take the company to a greater heights, right? But the fact that he has left now worries you, now worries your credit decision, right? On the other hand, when the company directors have changed, you must make sure that if they are authorized signatories of your account, that from a particular date, maybe from the date he resigned, say 25th of July, from the 25th of July, or perhaps after the 25th of July, any document that comes from the company cannot have his signature, right? Cannot have his signature. So when it comes to change in directors, right? A new Form 20 is served on you. You need to see, that's a change in directors. Don't put it under the drawer. You take them and see who is changed, who has left the company and who is in the company, or whether only one person has left and there is the existing directors are still there, right? So if a new person, as I told you, if a new person has come in, make sure that your mandates are changed, right? That the mandates are changed. Any questions on that? Right. We are moving on. Subsidiary companies, right? Subsidiary companies are, you can be a fully owned subsidiary. Say this is a company, and their shareholder is B, right? So this is a fully owned subsidiary. A company is a fully owned subsidiary of B, right? Because it has B is the 100% shareholder of A company, right? It's the fully owned subsidiary of B company. Sometimes you see the most common form, some banks have fully owned subsidiaries of finance companies. Say UB Finance, or maybe Siapata Finance, UB of Union Bank and Siapata of Sampat Bank. The finance companies are 100% fully owned subsidiaries of those banks, right? Now, if you, once again, as I told you, if this is going to be changed, right, this will affect your credit quality. So in the offer letter, you always say the shareholding structure shall not be changed without the prior written consent of the bank, right? Right. Cross holdings is where one company becomes a subsidiary of the other, and the other becomes a subsidiary of the other party. A cross holding is now not allowed under the New Companies Act. Before we move on to ranking of claims, we will take serious loss of capital, right? The serious loss of capital is under the New Companies Act when the net assets of the company are less than half of its stated assets, right? Net assets of the company are less than half of its stated capital, then you see that there is a serious loss of capital. Now, when the board gets to know this, it is the duty of the board to convene an extra general meeting, right? And to inform the shareholders about the serious loss of capital, right? The notice which they are convening the meeting should be accompanied by a report stating the nature of and extent of the loss, the causes of the loss, and the steps that they have taken to prevent further losses, or what they're going to take in respect of the loss which has already incurred, right? The impact on the bank is it will reduce the creditworthiness of the customer, since the customer will involve in a transaction that will reduce its stated capital below 50%, right? So in a situation like this, we must make sure that the company does not sell any of these assets, because when they sell any of the assets, the customer's strength will come down, right? We are moving on to meetings. As we earlier discussed, board meetings. What is important in a board meeting is, now as before, it need not be in physical meetings, right? If the articles allow, you can have your virtual meetings as well. But what is important is you should comply the proceedings as laid by your articles, right? Now, the articles of the company will say how many days notice that you need to give to convene a general meeting, right? This is important. The time frame before you conduct a meeting. That is what is called the notice of meeting. Why this is important is, when this comes of paramount importance when there is a dispute between directors, right? When there is a dispute between directors, the ones which are in connivance with each other tend to avoid the other director, right? The troublemaker is tend to be avoided. So, because any board meeting, board resolution can be challenged if they are not in accordance with the notice of meeting, because this person can come and challenge, right? So therefore, of course, we cannot go to that extent. But if there is notice to the bank by a director, right, about the dispute, you need to be a little cautious, right? Sometimes directors do write to the bank and say, there is a dispute between us. He is going to do this and I am not in agreement, this, that, and the other, right? Can you all recently, perhaps sometimes the directors do write to the bank and say, maybe in respect of a particular matter, he is not in agreement, and or perhaps that there is a dispute in respect of the company, don't allow the authorized signatories to withdraw money, right? Maybe you might get a letter from this particular director saying that there is a dispute and please don't allow the company to withdraw funds, right? Then a situation of that nature, what is the recourse that you take? You get a letter, I'm repeating, you get a letter from a director saying that there is a dispute in the company, right? Therefore, please don't allow the company to withdraw funds. What do? What is the course of action that you're going to take rather? Any answers? I'm sure you all would have got this type of letters from your customers. say a director of a particular company writes to you saying that there is a dispute in the company and tells you not to let the others withdraw funds. Do you act on this letter or not? Yes or no? Can you act on this letter? Yes or no? Are you there? Yes, I know you are there. Do you act on this letter? Thank you. Do you act on this letter or not? Yes or no? The answer is you cannot act on this particular letter. Why? Right? It is only a letter that you have received from the director. It is not a board resolution, but you need to be careful. You need to be vigilant. Understood? Say this director writes to you, but who are the authorized signatories? A and B. A and B are the authorized signatories, right? They send you letters, right? But this director is not an authorized signatory. So what is your recourse? You can be vigilant, but on the strength of this letter, you cannot say that this company cannot withdraw. You cannot say that because there is no board resolution to change the authorized signatories, and this is only a letter issued by the directors, right? Only thing is you can be vigilant until a board resolution comes in, right? Right. So that is for board meetings. The other thing is the quorum should be regular. A meeting should have a quorum, right? Every meeting will have a quorum. Maybe it's two or four or whatever it is, as the company may decide. And it is extremely important that you have the quorum to start a meeting. Otherwise, the meeting can be held ineffective, right? Annual general meetings. Annual general meeting is a meeting, as you see from the name of it, that it is held annually, right? 6 months from the date of the balance sheet, you need to have your annual general meeting. At the annual general meeting, your accounts should be approved, right? And the appointment of directors and the appointment of auditors should take place, right? If the company has profits, right, that can be distributed subject to you taking the solvency certificate, right? So extraordinary general meeting is also a type of general meeting that you have, as I told you earlier. This is in respect of change of articles or issue of shares, right? Proxy. Generally, proxies are there in very much common in PLCs, right? If a person cannot come to vote or cannot be in person at an annual general meeting, they can give what is called a proxy, right? It is a document where you write your name and where you tick whether you are in agreement or in disagreement in respect of the resolutions that are going to take up at the annual general meeting, right? Proxy should be lodged 48 hours before the meeting starts, right? So we are moving on to the interest register. Interest register is to write down the interests that the directors have in transactions, right? Have you seen, this is more when it comes to the regulated companies or the companies which are listed in stock exchange. When there is a dealing by a director or something that a director has an interest on, you need to inform it to the Colombo Stock Exchange as well, right? Now, as I told you last week, this is the time where you get a lot of companies which are in distress, right? The companies are now facing a lot of difficulties, right? So under the Companies Act, when the companies are finding it difficult to move forward, what are the provisions do you think that they have, the Companies Act has? Any answers? If the company cannot carry on its business, right? What is the recourse that the company would have? Any answers? Yes, companies can merge. Yes. Companies can close down, right? Companies can wind up. Very good. Apart from this, right, the companies, in the new Companies Act, there is a special provision which was not there in the previous Companies Act. Other than for winding up, the companies can enter into what is called this. The companies can come into a compromise, right? Now, what do you mean by this? When the company is not doing good, right, it is not that you should necessarily wind up, right? Say in a situation like this, most of the companies may not be doing good. That does not mean that the company should be wound up, right? Here, we need to give the company a little bit of breathing space, right? To give the company some breathing space, there are certain provisions in the Companies Act, right? One is, now, to do all this, the directors first must identify that there is a problem of this nature, because the directors have a major duty towards the shareholders, perhaps the creditors of the company, or perhaps the employees of the company. The directors have a major role, right? Therefore, it's kind of a fiduciary duty, right, that the directors have. So in this scenario, directors cannot just let the company go wound up. No, perhaps they can carry on it under these circumstances, right? These circumstances, they can resolve that they appoint that they would appoint someone called an administrator, right? They can appoint under the Companies Act person called an administrator. When an administrator is appointed, the board steps back. The board steps back and allows the administrator to take on the company to steer the ship, right? It will allow, the company will allow the administrator to take on the company. The board will step back, right? And the administrator, after a certain period of time, would tell the directors whether it is possible to carry on like this or whether they will come out of the present situation, right? So in this scenario, an administrator can negotiate with creditors, right? They can negotiate with creditors, right? Or else the company itself can go to court, right? And come up with a proposal with a class of creditors. With a class of creditors, right? Say unsecured creditors. They would address the onset of unsecured creditors and say, look here, at this time, we cannot settle 100%. We would rather look at settling 75% at this moment, right? And as a measure of goodwill, we will say settle you this amount of money for the next 2 months, right? And this amount of money the next 4 months. Likewise, they can come into a compromise, right? If the 2/3 of the class of creditors agree upon this compromise, they can move forward, right? So those are the provisions that you see in the Companies Act, right? When it comes to where a company is not doing so good, perhaps the companies are in distress. Distress can be, or companies' distress can be for different matters. Maybe the company has been mismanaged, right? Or perhaps the company has done something fraudulent, right? Or perhaps, or in the present COVID scenario, even the companies can be distressed. Now, the reason for distress is not, what is important is not the reason for the distress. The fact that the companies are, if the companies are in distress, then what I want to stress is, rather than straight away going to winding up situations, right? The companies the companies have provisions for revival. They have provisions to see whether they could have some breathing space, right? Whether they could have breathing space, right? So that is what I want to stress to you when it comes to the revival rather than the winding up, right? So we spoke about the changes. Then, yeah, we are moving now on to the winding up. Winding up of a company is to basically close down the business of the company, right? It can be done by winding up by court or perhaps by voluntary winding up, and also by supervision by court. Those are the three instances where you can winding up, or a company may be wound up by court if the businesses are suspended for more than a year. Say there are no directors. Generally, when, say, in a company, there are 3 directors, right? Say A has resigned, right? B is mentally incapacitated. C is dead. Now what to do? What you can do is to wind up the company, right? Unable to pay its debts, insolvency, right? And if the courts see that it's just an equitable to wind up the company, the court can wound up the company, right? Unlike in the previous Companies Act, in the new Companies Act, without the involvement of court also, you can wound up a company. That is called voluntary winding up, right? Now, when it comes to winding up, once the winding up decision is made, a liquidator should be appointed, right? A liquidator is a person who would look into the company and see, okay, there are this much of assets. These are the people who owe the company, right? And this is how you are going to settle them, right? So the slide that I skipped before, ranking of claims, right? When a company is in a situation of this nature, right, there would be a ranking of claims, right? As you see in this slide, it will be the liquidator's payment first. That's number 1. Though whether you have money or not, he will take his payments first, right? Then you have to make sure that the liquidator has to make sure that all statutory dues, that is whatever that is due to the government, has to be paid, right? And then only can you see the secured creditors come in. That is where we step in. And thereafter, unsecured creditors, right? If we have not filed our Form 10, we can fall into unsecured creditors, right? So before you give a loan, perhaps it is important for you to know whether all statutory dues have been paid, or perhaps in this situation when a customer comes to you, I know at this moment they are distressed, but make sure that they have paid all their statutory dues. That is their EPF, ETF, and the gratuity payments, taxes, this, that, and the other. Because a large portion of the company's balance assets goes to them, the secured creditors, will basically have nothing to take from, right? So as you see the Companies Act, right, there are a lot of provisions for companies to carry on businesses. There are pluses as well as minuses. I'm sure I don't know whether you have touched on the director's duties, but as you could see from the two sessions that we had too, the duties of the directors are large, right? Because they steer the ship. They have responsibility, as I said, towards the company, the employees, the creditors, any person. They have a fiduciary duty, right? So those are now quite codified under the Companies Act. And if they don't adhere to the Companies Act provisions, which are of course made to the betterment of the company, right? The betterment of the stakeholders, there is provision for civil as well as criminal liability, right? Having said that, companies also have duties like the Solvency Test, which runs through like a silver line when it comes to distribution and anything that is taking the money out of the company, right? And breathing space in respect of companies like appointing an administrator. Also, breathing space by amalgamating companies, either for betterment of the company or when you are financially distressed, right? These provisions are there for the company, but certain provisions of the Companies Act itself would bring the creditors perhaps at a kind of a disadvantaged situation. Here you see at one point the companies are allowed to change its shareholders, right? But on the other hand, if your credit decision was based on the strength of the shareholder, here your credit evaluation is hampered, right? On one hand, the companies are allowed to appoint administrator. The moment a company allows an administrator, the banks cannot go further action until notice, right? Until the company, the administrator comes up with a proposal, or perhaps you cannot immediately go into recovery positions, right? And that is why, because of these kind of restrictions, this is why we have always in our offer letters and our security documents, we have said, though you have the provision under this Companies Act, you can't do this. You need to keep us informed. You need to take prior approval. Is that and the other, everything under the sun we put in our offer letters, right? But still, if you look at the practicality of it, nothing in actual scenario comes for prior approval. But having said that, the company, once they sign the offer letter, they are bound, right? They are bound by the terms of the offer letter, and perhaps as banks, in a situation which is quite disadvantageous to the bank, perhaps we would be rather in a better position to bring recourse to our banks, right? So as I told you, the salient fee we discussed today and the previous day, the salient features of the Companies Act, which are important as applicable to the companies and to the banks. And we discussed about the type of companies and other entities basically the corporate sector, and we knew that we need to give solutions to our corporate customers. And to give solutions, we need to really know what the real background, or perhaps the real law, or perhaps why would we require certain documents or certain information from the customer, so that it is easy for us to handle the customer and to give a better service, right? So with that, I would like to conclude the session today, leaving room for you for any questions to take up from here. Well, amalgamation and mergers are not quite the same. They are two different things. Though you see both as the same, amalgamations are rather covered under the Companies Act, right? Mergers are under the Merger and Acquisition Code, right? So there is a difference between an amalgamation and a merger. You can ask any questions in respect of the sessions that we have, or have we had, or any other questions in relation to any legal matters, that in relation to your day-to-day matters. When it comes to actually the Companies Act, though it is about, say, more than 10 years that the Companies Act has come into effect, we have very little case law in respect of the company matters. So we do have the provisions, and we act by those provisions, but still some of these provisions are not very much tried and tested. So actually there should be a case which should come up on certain concepts of law, so that the real picture, or the real finer points can be tuned. Who can request for a solvency test? The company can request, or even we can request for a solvency test. As creditors, we do have that right. A shareholder can request. Yes. We have a question. When we are placing the embossed seal, why the company seal count the number of placements? This is actually this is something which comes in the practice, right? They need to know how many placements that they have kept in the particular document. That's because they need to say 7 placements in this particular document. This is a safety measure. There is no law, perhaps, I don't know whether there are any case law, but this is more or less in Sri Lanka a practice. Any questions? Any more questions? Since there are no questions, then shall we wind up for today? Right. Then we will wind up for today, and hopefully we will have a next session maybe on the law topic or perhaps some other topic. So thank you very much for being with me for the last 4 hours. Be safe and have a nice, a joyful week. Thank you.